it is really truly impressive to see how many experts, world-class experts, you have been able to bring together for this dialogue on child abduction matters and how to continue to improve the situation. My task, the task I was given, was to talk to you a bit about the Hague Conference on Private National Law in general, which I'm of course more than happy to do. All the more so as we realize that when we are addressing a certain group of experts who are very familiar with one or two very specific Hague Conventions, they still actually don't know the fuller picture of what else the organization is doing and how the organization is operating, what the reality of the organization is. So I'm going to give you a bit of a background as to the work of the Hague Conference, give you a bit of a framework within which the Hague Child Abduction Convention operates, and also maybe try to look ahead a bit, and in particular mention a few things in relation to the upcoming Special Commission on the 1980 Child Abduction Convention. The first thing I like to do in those circumstances is to solve a mystery, I hope, because very often we're being asked, why HccH? What does HccH actually mean? Hague Conference, and then what's the CH? Well, that's actually quite easy. Our two official languages are English and French, so if you put the English together and the French together, Conférence de la Haye, HccH. Okay, so now you know it. First mystery solved. The other then is, what is the Hague Conference on Private National Law in general? Well, of course, it's an intergovernmental organization, as you all know, but the origin of which goes back to 1893, which makes us the oldest of all the 160 plus international organizations based here in The Hague. You certainly also have heard that the OPCW was given the Peace Nobel Prize this year. Well, the Hague Conference got it indirectly in 1911 already. Tobias Asser, the founding father of the Hague Conference, received his Peace Nobel Prize in 1911 specifically for having launched the Hague Conference on Private International Law. Who knew that? We are also different from the other organizations here in The Hague in the sense that we are the only one with a legislative function. So as you know, we are not a court, we are not a tribunal, we just do the law in the form of international treaties or the Hague Conventions. All these Hague Conventions, they do address private law problems as they arise among individuals or companies in situations across borders. But what is really important for me to stress here is that the Hague Conference does not only deal with family law situations, cross-border family law situations involving the protection of children, but we also deal with cross-border commercial issues, with cross-border business deals, with financial transactions, or there are a number of conventions, successful conventions, which establish a very effective framework for legal or administrative cooperation across borders. So all these conventions, they either deal with jurisdictional issues, with matters of applicable law, with the recognition or enforcement of foreign judgments, or again, they establish a very efficient framework for legal cooperation or administrative cooperation, such as the Hague Child Abduction, really. It's not a typical private international law convention, and it's actually interesting to note that some of the most successful Hague Conventions are not typical private international law conventions, but rather conventions that do establish a framework for effective cooperation across borders. So how do we do all of this? Well, as I mentioned, in the form of these Hague Conventions. There is a total of 38 Hague Conventions out there. So the Hague Child Abduction Convention is one out of these 38. Now, I will be very honest and transparent with you. Not all of these 38 conventions are equally important, certainly not as important as the Hague Child Abduction Convention. Some of them are actually not even in force. But I think it's fair to say that there is a core of about 12 to 15 Hague Conventions that do establish international standards very often, that practitioners, that investors also expect to be in force in a jurisdiction before they enter into a specific transaction. An interesting feature that has always been the case for these conventions is that they are open not just to the members of the conference, but also to non-members of the organization. And I will show you on a map how that looks, because it's actually quite an impressive feature. But I think what also distinguishes the Hague Conference on Private and National Law from many other intergovernmental organizations is that, yes, we do these new conventions, but it's one thing to put the conventions on the table, it's another thing to make them work in practice. And that's why the series of post-convention services that we offer at the Hague Conference have become so important. They can take different form. There is, of course, the special commission meetings, which bring together experts from all over the world to discuss the practical operation of conventions and to adopt conclusions and recommendations, which are very, very important to guarantee as much as possible a uniform interpretation and operation of the conventions. But there is also all a series of publications and handbooks and guides to good practice, which we publish and which do, I think, help support the effective operation of these conventions. And for those of you who are interested, the most recent of these publications is, of course, the handbook on the 1996 convention, which I think will greatly help the operation of this convention in future. But these post-convention services, they include the promotion of the instruments, the assistance and the help with the sound implementation of the convention in the specific jurisdictions, and then also the monitoring and the review of the practical operation of these conventions. Now let's have a look at this map that I refer to on the members of the Hague Conference. This is the map with the members in dark blue. And as we speak, we have 76 members around the world. That is 75 states, plus the European Union as such, which in addition to all its own members, is also a member of the Hague Conference on Private International Law. Now, we have a few states also in the pipeline, as we like to say. There is a series of 3 states, Colombia, Lebanon, and Azerbaijan, which have been admitted already as new members. That means that they have successfully gone through a 6-month voting period among the existing members to be admitted as a new member. But for them to become an actual member of the organization, they still have to deposit their instrument of acceptance of our statute, and only then will they become members of the organization. We have, or until recently, have had 2 states that were ongoing this 6-month voting period, Armenia and Tunisia, but just yesterday we sent out the procès-verbal reflecting the result of the voting period for Armenia's admission, which was positive, and so Armenia is now also an admitted state and has been invited to deposit the acceptance of the statute and thus then become a member of the organization. But really, I think the point of this map is to say that personally, I don't feel comfortable to say that the Hague Conference is a truly global, universal organization when you look at that, because there's an obvious gap. And the gap is Africa, and the gap is also in some parts of Asia Pacific. So this is where our efforts really go, and I think it's important that we increase the visibility of the Hague Conference and the relevance of its work in all these different parts of the world. I said 76 members, but of course there is a big but. And the but is, as I mentioned, that a state doesn't have to be a member of the organization to be a party to a convention. And this is a map that then shows all the 144 states that are somehow connected, as we say, to the work of the Hague Conference by either being a member of the organization or, without being a member, by being a party to at least one of our conventions or in the process of becoming a member of the organization. And this slide, I think, looks much more comforting in terms of the global universal reach of the Hague Conference. And one of the things we obviously try to do is to encourage states that are not members, but contracting states to at least one convention, to become a member of the organization and to contribute to the budget. That's the second part of the sentence. I'm not sure you know that we also have a regional presence. Of course, we have our headquarters here in The Hague, the Permanent Bureau. Now, those of you who don't know the Permanent Bureau, this is a picture, and I'm sorry if I disappoint you if you imagine that this Hague Conference was this big thing, as big as the European Union or the United Nations or what have you. No. We are about 30 people working at this office, doing all the work on the basis of a budget of about 3.7 million euro, which very often also surprises people to see how little and how small this budget actually is. And yes, indeed, it is a small budget, but it's the reality. But the point is that we have opened a first regional office in Latin America, in Buenos Aires in 2005, and then also opened one in Hong Kong in December 2012. And the point really of these regional offices is to have people from the region talking to the people of a region, because that makes a whole difference. It's one thing to have our representative who happens to be Argentinian, or our representative in Hong Kong who is of Filipino origin, to talk to the people in the region and to explain the work of the Hague Conference and to explain the relevance of our work, as opposed to have the guys from The Hague coming down and preaching the word. So it makes a whole lot of a difference to be closer to the regions and promote our work. And again, looking at the map, you can easily imagine where we believe the next regional office should be. Africa is, of course, the destination. Now, what our conventions very often do is they give effect really to human rights. And one very prominent example, of course, is the 1989 UN Convention on the Rights of the Child, which is in force in almost all the countries of the world, and I'm going to leave it at that. But as you know, the UNCRC has a series of rather broadly formulated general principles that are announced in various articles. An important article, of course, is Article 3 of the CRC, which mentions that in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be the primary consideration. And that, of course, is also the principle underlying all our child protection conventions, including the Child Abduction Convention, but also the Child Protection and indeed also the Adoption Convention. But what these conventions do really is they give effect to some of these general principles announced in the CRC, and so states join our Hague Conventions and thereby kind of implement the general principles mentioned in the CRC. A quick word on what's going on at the Hague Conference right now. We just had our council meeting on General Affairs and Policy, which is the highest organ of the conference and which also determines the work program. We are very well advanced on the first of these projects, which is Choice of Law in International Contracts. So that's a B2B instrument, the first soft law instrument developed by the Hague Conference. It's a series of 12 principles that are being developed to promote the idea of party autonomy and to enable parties to a business-to-business contract to choose their law effectively. And there is also the Judgments project, which of course has a huge history, which I'm not going to summarize here, but the idea is to develop first a series of articles dealing with the recognition and enforcement of civil and commercial, or judgments in civil and commercial matters, and then to see also if this can be expanded and also include some provisions on direct grounds of jurisdiction. So that's the more commercial side of things where the projects are well on track. But in the family law side of things, we have also quite a full pipeline. There is a first project which is commonly referred to as the surrogacy project, but I'm actually not quite sure that this is the best title for the project, because it has the risk of putting some people off just because of the reference to surrogacy. When in fact the real purpose of the project is to see how the fundamental rights of a child born out of these alternative arrangements of procreation can best be protected, including, of course, as regards the question of legal parentage. You know, whose kids are these child, and who are the parents of these children born out of surrogacy arrangement? This is ongoing work. The Council has decided this work should be continued, and will probably take its decision at next year's Council to see if time has come to convene an experts meeting. The other project is one on the recognition and enforcement of voluntary cross-border arrangements, including mediated agreements. It is of course true that the 1996 and also the 2007 Convention on the Recovery of Maintenance Obligations do help with the recognition and enforcement of voluntary agreements, but there might be problems when different authorities have jurisdiction for different parts of package agreements, which may deal with the question of custody, with contact rights, with travel arrangements, with maintenance provisions, or with property issues. It is sometimes difficult, also we are being told that it may be difficult to have such package agreements being recognized and enforced abroad when they are based on voluntary agreements. And so one possible solution is to develop a soft law instrument as a sort of a navigation tool in order to determine how to make agreements recognized and enforced portable in all countries involved. The other option is to develop a new binding instrument with a view to providing a sort of a one-stop shop where the parties could go to one authority, deal with all these matters, and have them recognized abroad. That is, again, also ongoing work. Then finally, there is a project on the recognition and enforcement of foreign civil protection orders, which is a fairly new proposal. We have had one meeting of an experts group. The Council agreed that more work is needed there, in particular also to see the statistical importance or the practical importance of these civil protection orders, and to see to what extent they are actually produced abroad in a different state and need to be enforced in a different state. So again, that's for ongoing work. Now let's come to the Child Abduction Convention. That is the map that I think you are familiar with. 92 contracting states of the convention as we speak. As you see, again, a similar sort of coloring with certain parts of the world that are still in gray and where more work needs to be done. Now, of course, there have been some very important developments, including in the very recent past with respect to the convention. You all know that the convention has entered into force in Japan on the 1st of April, which is a significant development. But very recently, and you may not have heard that because it really just happened at the Council, Iraq acceded to the Child Abduction Convention, which again is of course a truly significant development. And I can tell you that we are talking to the embassy here already to see how we can help and assist them with making the operation of this convention in Iraq effective, because it is clear that they need help and assistance to make this work in practice. Iraq is not a member of the organization, though, and that has some limitations as to the accessibility to technical assistance, and we also encourage them, therefore, to consider to become a member of the organization to have a facilitated access to technical assistance. The interesting thing when you look at the statistics of the development of the number of contracting states is that the convention, despite its mature age, shall we say, continues to attract new contracting states at a fairly high rate. And that is good, it's encouraging, but again, there is always more work to be done and more states to bring into the convention. The role of the Permanent Bureau is very diverse in those situations to try and encourage states to become a party to this or other conventions, but with respect to the Child Abduction Convention, of course, we encourage newly acceding states to look into the twinning or mentoring program that we have, where we encourage their central authority to go and visit a central authority of a contracting state where things operate well. It is a wonderful experience for them to gain, to see how things are being done in a well-functioning central authority. There is, of course, the country profile that we invite them to fill in, and we actually push them to fulfill the country profile and to answer the questionnaire for newly acceding states. All this information is, of course, made available then on our website. I take it that you are familiar with our Malta process, which really brings together contracting states and non-contracting states whose legal system is at least partially based on Sharia law, to see how these states can eventually also be brought into the convention, but in the meantime, how joint mechanisms can be developed for the effective return of children in child abduction situations, including on the basis of mediated arrangements. And then we do, of course, very much favor the dialogue with practitioners in all the fields of our work. It is truly important for us to know from you practitioners, experts on the field, how the conventions operate in practice, where the difficulties are, and what we, the Permanent Bureau, can do to overcome them. Our response really to all of this is that diplomacy and technical assistance work, they make a difference. And I mention here diplomacy in particular because I do want to take this opportunity to make a slightly more delicate, maybe, comment, but I want to bring to your attention what's happening in another contracting state in the US. I'm not sure if you are familiar with HR 3212, which is a bill that has been passed Congress in December 2013, and I have to be very delicate here and diplomatic because it is, of course, a domestic issue for a contracting state, and it's not for the Hague Conference really to interfere with these domestic developments. It's also a bill that is very much supported by Sean and David Goldman. And you know, of course, the Goldman case, the Brazilian-US case, where it took about 6 years for Sean Goldman to be returned to the US. Well, if that bill were to become law, the President of the United States has then the power to adopt sanctions vis-à-vis states that do not comply with their obligations under the Hague Child Abduction Convention. It also invites the President to enter into bilateral agreements or memorandums of understanding with other states that are not yet party to the Hague Child Abduction Convention. And again, if these memorandum of understandings or bilateral agreements are not fulfilled, then sanction, including economic sanctions, are the answer, apparently. Well, personally, I have to say that I don't share that approach. I don't think that the right answer is in sanctions. The right answer is in talking. The right answer is in trying to convince more and more states to come into the Hague Convention and to help them, assist them with making the convention work effectively. It is a development that we continue to observe and look at with a great deal of interest. I've talked about the guides to good practice and the practical handbooks that we have developed, in particular with respect to the child abduction conventions. Of course, it's the one on the central authority practice, on implementing measures, on preventing measures enforcement, and in particular now the last one on mediation, which has been so well received, and I think for very good reasons. And I do understand that mediation will be an important part of your conference, so I'm not going to really go into details here. The Judges newsletter is also a publication that we issue, which I really wholeheartedly recommend. It's called the Judges newsletter, but it's equally interesting, I would have thought, for other practitioners. The latest volume of the Judges newsletter is on concentrated jurisdictions, and it has some very informative articles. The other tool that I really want to bring to your attention, I'm sure you're familiar with, is INCADAT, our international child abduction database. But there again, I have to tell you that we are facing challenges. We actually recently had to put an end to the contract of one of our consultants that we had, who helped us feeding the database with new case law, simply because we don't have the funding. I was telling you what the budget is. Well, this is part of the difficulties then that we have. We are currently down to one external consultant and a wonderful team at the PB trying to keep the INCADAT database up to date as much as possible. But believe me, it's a struggle. If you want to continue to be able to benefit from INCADAT, we have to find a solution, and we have to find some external funding to really keep it up to date and continue to upload cases. There are currently slightly over 1,000 cases in this database, but more work is needed. Another thing that I wanted to mention and bring to your attention are statistics. I personally like statistics. I think it's important to have access to relevant, updated statistics to get a clear picture of how a convention, in this case the Child Abduction Convention, operates. And here I am standing in front of you showing you a 2008 statistic. The reason is that we don't have more recent comprehensive statistical information on the practical operation of this convention. I personally believe this is wrong and we should do something about it. And I have therefore instructed the office to make sure that INCAStat, the International Child Abduction Statistic Program, be implemented in the coming weeks. We are reaching out to all the central authorities of the Child Abduction Convention, and we will invite them to provide us up-to-date statistical information on an ongoing basis, because currently this has been done from one special commission to the other. But I don't think this is satisfactory, because things are evolving, things are changing. From 2008, where you see that the most prominent form of return was still judicial return. Now we see in other statistics and some more recent statistics that we have, say from the US, from Quebec, or from Germany, that voluntary returns are getting more and more, not just important, but actually the majority of return situations. But we don't know if that is reflected in the same way in the overall picture of the operation of the convention. It is something that I want to push for the next special commission, which will be held either at the end of 2015 or early 2016, And one factor we'll take into consideration for the timing of the Special Commission is also the return on these statistical information that we are looking for, because we need to have a more specific, more precise picture of how the Convention operates. I'm going to skip some of the next slides just to say that we were, of course, I guess like many of you, a bit concerned about Neulinger and related cases. We were then rather relieved to hear about X versus Latvia. We are also, I think, very confident and pleased with the results of the positions taken by the US Supreme Court in the 3 cases that made it to the Supreme Court. That slide I do want to show to you, and that's the concentration of jurisdiction, because when I first saw it, I was actually surprised in the positive sense that there are already 43 contracting states with concentrated jurisdiction. And just yesterday, I think the implementing legislation of the Russian Federation has been published, and from that implementing legislation also it becomes clear that Russia is also working on the basis of concentrated jurisdiction and wants to implement concentrated jurisdiction. I also understand that in Brazil, 2 out of 5 of the federal regions have concentrated jurisdiction. That's fantastic. I do remember that when I joined the conference a while ago, one of the first big tasks I had was to organize the Rufenberg seminar. And Matthew, you will remember it because you were one of our very distinguished guests there. Concentration of jurisdiction was one of the big things that we discussed, but back then there were a handful of states really that had concentrated jurisdiction. Now we are here with 43 contracting states already, and all the advantages that it brings. The judicial network and judicial communication was another big topic of the Rufenberg 1 in 1999. We launched the judicial network at the Rufenberg 1 in 1999. Today, 60 states, 91 judges who are party of this network, and which really help also the convention to operate effectively, because there is a dialogue among experts and a quick dialogue that is possible. I refer to the newest edition of the Judges' Newsletter for a very compelling story about a recent case between England and Germany, where within 2 weeks an Article 15 declaration was produced on the basis of direct judicial communication. The interesting thing about this slide also is just if you look at the Americas, it's impressive to see how much of that continent has implemented already judicial networking. Mediation, I'm sorry, I have to, in the interest of time, go and skip this, but of course, mediation is absolutely crucial and important for the effective operation of the convention, and I do salute here all the work that's being done by the NGOs to help support effective mediation mechanisms. They help to prevent child abduction, and they help to find suitable solutions when things have really got worse. The last slide I quickly wanted to show is looking ahead at the next Special Commission. I made my little sales pitch already about the need for comprehensive updated statistics. Nigel, wherever you are, I look forward to talking to you about this and see how best to make this information then available to you for your further reports, because I hope there will be another Nigel Law report on statistical developments of the Child Abduction Convention. Another big topic, of course, will be Article 13.1b. You know that we have a working group on Article 13.1b that is developing a guide to good practice. That will be ready for the Special Commission in draft form, and it will be submitted to the Special Commission for approval. And the overall objective, obviously, is to have as uniform as possible an application of 13.1b and the grave risk exception. As you can imagine, a very delicate but also a very important work that is ongoing. Another thing that is maybe a bit more, and I will be ending on this, another thing that is important to me, and I may be wrong, and I'm happy to be proven wrong if that is the case, but the issue of a modal travel consent form, to me, is an important issue because I do believe in it, in its preventive function. We had a discussion at the last special commission on the possibility to develop a model travel consent form, so where the parent who leaves behind gives his or her consent to the other parent to travel with the kids abroad. I have a special relationship to a model travel consent form because I developed my own when my wife was going back to Canada with our children. She is Canadian. I created my own model consent form, had it notarized, and each time she would go back to Canada, I gave it to her. And on many, many occasions, she was actually asked to produce this form. And for the immigration officer to see my consent on Hague Conference letterhead actually had quite some impact. And they said, oh, yeah, there you go, okay, fine, well done. At the last special commission, it was simply decided to sort of push this over to ICAO, to the International Civil Aviation Organization. That's fine. In the meantime, you may have seen the model travel consent form that has been developed, for example, by the ICAO Foundation. There are other model consent forms out there, but I think it's worthwhile considering putting this topic back on the agenda for the next special commission, simply because it may have a very important role to play in form of preventing child abductions. That's it. I do thank you for your attention, and I do want to take this opportunity again to thank the organizers and to wish you a very fruitful and an excellent discussion. I'm sure you will all enjoy your conference and hopefully also your stay here in The Hague. Thank you very much for your attention.